Welcome to J is for Justice podcast. If live breaking news and following true crime is your thing, then please consider subscribing to my channel. And if you like what you see in my videos, please consider giving them a thumbs up.
Hello, are we live now? Are we live? Welcome back to J is for Justice. Let me know if you can hear me in the chat. Welcome back, guys. We got Bryan Kohberger, desperate to delay, is what we're going over today. Welcome in. If you haven't hit that like button, now is a wonderful time to do so for your favorite creator. Just kidding. What's up, jammers? Are you back from your vacation? What's up, Cole? Good to see you. Beans, Tempest, Robat. Miss Shell is here, and so is Cheryl T. You guys are here for some Idaho 4, Angie G, and Sherry. Good to see you. Hey, Candy. Hey, Flo. Sound is good, says Flo. I guess we're good to go then, as long as Flobo says so. Hello, Sarah. So we got a couple things that have been filed, as well as the motion to continue for Bryan Kohberger. And then we're going to get into a discussion here on law and crime with a lawyer about what can happen to those leakers. You know, the leakers of the Dateline episode, Bombshells, seems to be one of the reasons he's asking for this to be continued. But we're going to walk through it. We're going to read through these motions. And then, like I said, we're going to hear from this goofy lawyer. But he seems to think whoever made the leak is going to lose their job. Like their career is over. What do you guys think? Do you think they're going to get to the bottom of it? I don't know. Let's get into this, though. Welcome in. If you're just getting here, make sure that you do hit that like button. It is very, very helpful and free. It's a free way to get this video out into the YouTube algorithm. So if we go here to the Ada County, we're going to go to defendant's motion to continue. And here we have 40 pages of pure and tailored Bryan Kohberger bliss. Let's read through it. It says State of Idaho versus Bryan Kohberger with a motion to continue. And here we are. Let me just preface this by saying we are here, about a month, 2 months away from jury selection. About 2 months and 2 weeks away from trial starting. And what do the Kohbergers do to the Goncalves family? Have you guys heard about this? It's infuriating. There was a certain group of people that reported the Goncalves family Facebook page. You know, the one with all their memories on it. Excuse me. So sorry. You know the one with all their memories on it? That they put all those things that people sent them and through their grief for the last 3 years? The group is taken down. Their group is taken down. So I don't even know what to say about that. Why anyone would even fuck with them, but it's sick. Thank you. It's honestly, truly sick. So then there's another thing that I wanted to let you guys know about. Cara Kernodle, which is Xana's mom, has a GoFundMe set up. I did share it in the Facebook group. If you guys would like to help Cara Kernodle attend the trial for Xana, there is a GoFundMe set up by her friend. And I did verify it before I shared it. But yeah, for them to do that to the Goncalves, I don't understand it. I just don't. Those poor people, they've been through so much. So if you'd like to help out Cara Kernodle, the link is in my Facebook. All right, here we go. Comes now. Bryan C. Kohberger, by and through his attorneys of record, hereby respectfully submits the motion to continue due to the substantial amount of trial investigation and preparation still outstanding. What have you been doing, Ann Kohberger? As well as recent and forthcoming publicity that is highly prejudicial to the defense. Any conviction and sentence resulting from a capital trial beginning in August 2025 will be unconstitutionally imposed and, therefore, vulnerable to reversal on direct or collateral review. In making this motion, Mr. Kohberger relies on his right to be free from cruel and unusual punishment, his right to due process, his right to a fair trial, his right to counsel, his right to present a defense, his right to confront witnesses, his right to a fair and reliable sentencing determination, and other rights safeguarded by the 5th, 6th, 8th, and 14th Amendments of the United States Constitution. And then she has her table of contents. So here is number one, or the argument. This court has an obligation to uphold Mr. Kohberger's constitutional rights by vacating the trial date because defense counsel needs additional time to review discovery and prepare for the complex merits and sentencing phases unique to death penalty cases. Isn't Ann Kohberger working on a death penalty case in addition to this one? Isn't this her second death penalty case that she's currently working on? Maybe don't work on two. And what have you been doing for the last 3 years? What have you been doing? As detailed in this motion, moving forward with the capital trial in August will infringe on Mr. Kohberger's constitutional rights as counsel requires more time to review discovery, complete investigations, and prepare for trial. What? When considering this request for a continuance, the court must weigh the issues against the heightened need for reliability in death penalty cases. When the state seeks death penalty, it imposes an extraordinary burden upon the court itself and the defense counsel to ensure the fairness, accuracy, and reliability of the trial and any subsequent sentencing proceeding. With a defendant's life at stake, the court must be particularly sensitive to ensure that every safeguard is observed, and they must take extraordinary measures. Number two, Mr. Kohberger has a myriad of constitutional rights during these proceedings, all of which are dependent on counsel having the time and resources to prepare for a capital trial in accordance with established professional norms. In capital cases, the rights to effective assistance of counsel and a complete defense are amplified. I'm just going to scroll through these case laws to see if there's anything significant. Here's B. Mr. Kohberger is also entitled to an individualized sentencing determination, a constitutional right that is uniquely reserved for defendants facing the death penalty, because the prosecution is seeking to execute him. Mr. Kohberger also has constitutional rights in this proceeding. The 8th Amendment requires that a capital sentencing proceeding permit individualized consideration of the defendant and the circumstances of the offense. The U.S. Supreme Court has repeatedly emphasized that in a capital case, a jury must be given the opportunity to consider all evidence that may weigh against a death sentence. That evidence includes anything at all from the defendant's life history and cannot be limited. When a jury is denied relevant mitigating evidence, either because counsel independently fails to conduct a complete investigation or because the court denies defense counsel adequate time or resources to conduct such an investigation. Then they talk about the 6th, 8th, and 14th Amendments again. C. The right to qualified expert assistance as part of the guarantees to effective assistance of counsel. In line with the heightened protections afforded to capital defendants are entitled to necessary expert assistance. Indeed, expert assistance is needed in all homicide cases, given that investigating a homicide is uniquely complex and often involves evidence of many different types. Analyzing and interpreting such evidence is impossible without consulting experts. I thought they had experts. What was Cy Ray? Wasn't Cy Ray an expert? I mean, am I missing something here? Sherry baby. Thank you.
Sherry has supported the stream using J4J Live.
Thank you, Miss Sherry. Thank you for the $25 tip. And Regina, thank you for 10 months of membership over here. And Shell, self-explanatory, with 60 months. Oh my God. Thank you, Shell. 60 months. That is really something to be proud of, man. I am so grateful for you. That's awesome. Who else can say they have had a member for 60 months? Not very many people. Not very many people on this platform. So thank you so much. I appreciate you so much. Okay. C. The right to qualified expert assistance as part of the guarantees to effective. I already read that. Looky who's here. Hello, Mr. Shane Culkin. And he's been a member here for 14 whole ass months. Thank you so much, Shane. He says Brian's done. Regina says Brian's cooked. Chris, 8 months, listening but can't chat. Work is holding me hostage. Well, I hope they let you go soon, honey, so you can jump in the chat over here. It's good to see all of y'all. As discussed further below, defense counsel cannot know the full range of experts that may be necessary until after the extensive social history investigation has been completed. Oh my God. We've only had 3 fucking years to do this. Counsel's professional and ethical obligations. Counsel's duty to provide effective assistance of counsel. In order to effectuate Mr. Kohberger's constitutional rights, counsel must at least meet the minimum professional obligations in the ABA guidelines. The ABA guidelines require, quote, high quality legal representation for all persons facing the possible or execution of a death sentence by any jurisdiction. Every task ordinarily performed in the representation of a criminal defendant is more difficult and time-consuming when the defendant is facing execution. The minimum requirements counsel must meet in investigating the merits phase. It says counsel must thoroughly investigate and challenge every minute piece of the evidence that the state purports to have. The defense lawyer's obligation includes not only finding, interviewing, scrutinizing the backgrounds of potential prosecution witnesses, but also searching for any potential witnesses who might challenge the prosecution's version of events. Isn't that what you do in every case? Yeah, stalling. C. Counsel must conduct an exhaustive, unparalleled life history investigation, analyze hundreds of documents and interview, and compile all this information into a cohesive narrative for the sentencing phase. Who thinks this is Anne or Bryan? Put a 1 if you think it's Anne. Put a 2 if you think it's Bryan. I say 2. I say 2. Compiling a life history requires 2 primary responsibilities, which are dependent upon each other. 1, collecting and analyzing the records from the client and the client's family life history. 2, interviewing individuals who have touched the client's life or who may be able to shed some light on the circumstances shaping the client's life. You think both? Ooh, Murdoch got beat up. No, I didn't. I did not see that. It is well established that life history records must be collected and are not limited to medical history, complete prenatal, pediatric, and adult health information, exposure to harmful substances in utero and in the environment, substance abuse history, mental health history, history of maltreatment and neglect, trauma, educational, employment and training, military experience, multi-generational family history, religious, gender, sexual orientation, socioeconomic, historical, and political factors. Oh my God. Lay witnesses must be interviewed, such as people as the client's family, extending 3 generations back. The client's friends, teachers, classmates, coworkers, employers, social service and treatment providers, someone familiar with the client's prior juvenile and criminal justice background, former and current neighbors, witnesses who can testify about the applicable alternative to a death sentence, and witnesses who can testify about the adverse impact of the client's execution on the client's family and loved ones. And then it says down here, footnote 3. Most individuals who are the subject of a forensic evaluation are not able to remember their life histories completely, will remember events inaccurately, and will omit critical facts such as the occurrences of head trauma. Certain important areas of information, such as prenatal history, whether their mother drank or took drugs during the pregnancy, early developmental issues, injuries, illness, exposure to environmental toxins, and genetic predispositions to illnesses are not likely known by the defendant. Only through gathering of records, repeated interviews with people who had contact with the client throughout his life, and all the analysis of this information can a complete life history be developed. Shouldn't she already know his life history? She's inviting his professor to come stay in the damn Airbnb. I'm pretty sure she's established history by now. I mean, just saying. Hold on. My cushion is all messed up. Pretty sure she's established family history. And if she ain't, I'm sure she can just ask fucking... What's her name? What's her name? Right. So he's going to come at his mom like, Mom, what'd you take when I was pregnant? When you were pregnant with me? Catherine Ramsland. This is a huge waste of time, and I hope that the judge denies it. Okay. Records indicating that the client's mother... Okay, so this is an example. Records indicating that the client's mother drank alcohol during her early teenage years would lead the mitigation specialist to question the mother, her family, and friends regarding the history of alcohol use, particularly whether she drank during pregnancy. To test and corroborate the responses, the mitigation specialist would gather the mother's school records, medical records, especially prenatal and postnatal health care records, all mental health and substance abuse records, school records, and social service or child protective agency records. This is a waste of time. Going back 3 generations. Is that due today? I don't know. Look at this. A multi-generational investigation extending as far as possible, vertically and horizontally, frequently discloses significant patterns of family dysfunction and may help establish or strengthen a diagnosis or underscore the hereditary nature of a particular impairment. The collection of corroborating information from multiple sources is a time-consuming task. Look at this. They want to look into fetal and birth trauma, prenatal malnutrition, problems in early development, physical illnesses, evidence of early or adolescent signs of mental illness or deficiencies, educational history, patterns of social behavior, including acting out in anxiety or tendencies towards isolation, change in mood and behavior, problems with hygiene and incontinence, low self-esteem, the history, nature, and extent of psychological, physical, and sexual abuse, a history and course of self-medicating behaviors, and subsequent drug and alcohol dependence, including the presence of traumatic experience, exposure to older individuals who introduced and or encouraged the child to use drugs or alcohol, the nature of relationships with parents, nuclear family, and extended family, residential history, including housing projects, foster homes, etc., presence or absence of social and community support systems. Oh my God. Poverty, number and nature of traumatic events, deaths of loved ones. I mean, come on. Well, you know, Thompson's waiting to retire, right, Lainey? Santa? Right, lead paint. I mean, do we need to do a forensic analysis of his childhood home? I mean, this is just ridiculous. Just ridiculous. Military history. Patterns of all significant relationships. And then we go on hundreds of thousands of hours to complete this. D, the alleged aggravating circumstances of this crime heighten counsel's obligation to conduct a full and complete investigation and prepare a presentation that can withstand adversarial testing. It should be noted that an integrated, comprehensive life history is not a luxury to be afforded to only some capital defendants, nor is it an excuse that stands no chance in the face of an aggravated crime. Rather, it's a vehicle that confronts and challenges the stereotypes of the, quote, natural-born killer, offering instead, quote, an examination of the structure of lives of those who commit violence. You can't tell me that Catherine Ramsland is not involved in some way, shape, or form. I just don't think I believe it. Here we have an example they're giving here. For example, Ricky Albeda killed a state police officer, a sheriff's deputy, his ex-girlfriend, along with her 18-year-old daughter and adult sister, another teenager, and a 6-month-old baby. Oh my God. He killed 1, 2, 3, 4, 5, 6, 7 people in a small New Mexico town of 2,500 residents. A jury sentenced him to life after deliberating for 11 days. Jason Burkett and a co-defendant killed 3 people, including a 16 and 18-year-old. A Texas jury sentenced him to life. And Andre Cooper was a gang leader convicted of killing 4 people, including eliminating a witness against him. The Pennsylvania jury rejected the death penalty. He's getting scared. Counsel cannot identify all necessary experts without completing the comprehensive life history investigation. I think so too. Bye, you. Enjoy your grand. You hear this? So they're saying they have to do this hundreds of thousands of hours of investigating his family and comprehensive life history before they can even do anything. Are you kidding? It's been 3 years. So here she's talking about reversals. There are numerous examples. This is about getting it right. There are numerous examples of capital case reversals because counsel failed to complete the social history investigation. Even when competent experts have been hired, because the evaluations resulted in inaccurate or incomplete information presented to the sentencer. Counsel requires additional time to fulfill the minimum requirements described above. A. Counsel cannot review all of the relevant discovery and complete the necessary investigations prior to trial. As counsel explained in recent filings and in oral argument, which are hereby incorporated in full for brevity's sake, it is impossible for the defense team to review the necessary and relevant discovery in a manner that allows the evidence to be integrated into the comprehensive defense case. She's tried this so many times before, though. We don't have enough time. We don't have. See, this is the kind of shit they try with Judge. And Judge would be like, okay, I'll give you more time. Wouldn't he? Judge would give him more time and shit. Hold on. Hold, please. I'll be back on camera in just a few minutes, but we'll keep going. We shall keep going. Oh, my allergies are killing me, you guys. Killing me. What is brevity? I don't even know what that means. This sounds like a bunch of shit. A continuance is also necessary to investigate and remedy the prejudice of highly inflammatory publicity released just weeks before the current trial date. This is Dateline. Here's Dateline. Including the recent Dateline NBC special and a forthcoming book. So we've got the James Patterson book fixing to come out. Let's see. Right here. This is coming out July 14th. This comes out. See, and this, I don't know how I feel about this stuff. Like, why can't they wait until until after the trial? Why do they have to write it before? So this comes out 2 weeks before jury selection was supposed to start, which I don't know if that really matters because the jury is going to be like questioned anyways. It does, I think so, Evelyn. Makes them look like they don't have a defense. Yep. Based on hundreds of exclusive interviews, the definitive account of the murders of 4 unforgettable college students by a cold-blooded killer. The Idaho 4 An American Tragedy by James Patterson and Vicki Ward. So that comes out July 14th. But they've talked to a lot of people. We know what it was like to live in Moscow on November 13th, 2022, the day of the cold-blooded killings. We know what the local police and FBI did right and what they did wrong. We've learned so much about the 4 heartbroken families, the Mogans, the Goncalveses, the Kernodles, and the Chapins. And we have the backstory for Bryan Kohberger, brilliant grad student, loner, and a parent incel, now indicted and facing trial. You are the jury. The evidence is in. What do you guys think of that? I mean, they're making it sound like they're bringing you all the evidence and you could be the jury. Just weeks before the trial. The Idaho 4 is much more than a true crime story. It's a vivid portrait of an American small town pulled apart by the murders of 4 young college students. The quest for a missing murder motive. Unmatched reporting. Unmatched access. Months of local reporting. Over 300 interviews with the victims' families, law enforcement, neighbors, friends, and faculty members of the University of Idaho. I agree, ministry. This happens all the time. We always see this. That's it. Publication comes out July 14th, 2025. All right, let's get back to this. This case has garnered substantial public interest, and the court previously issued a non-dissemination order restricting the release of certain information to the public in order to preserve the integrity of the proceedings and to safeguard Bryan Kohberger's right to a fair trial. Shane. On May 9th, 2025, just weeks before this capital trial is set to begin, NBC Dateline aired a 2-hour episode about the case titled The Terrible Night on King Road. The program includes details and materials, including video footage, cell phone records, and photographs of documents that are not publicly available through official channels. The show repeatedly emphasized the non-public nature of this information, stating it was obtained from unnamed sources who are close to the investigation, and that the materials were obtained exclusively by Dateline. Much of the investigative material presented by Dateline was taken out of context and will not be admissible at trial because it lacks reliability. The leaked materials appear carefully curated to promote a narrative of guilt. As this court acknowledged on May 15th, 2025, document and records hold order. The source of the leak is most likely someone currently or formerly associated with law enforcement or the prosecution team. If that is the case, it raises urgent and serious questions about the objectivity, judgment, and credibility of the individuals tasked with investigating and presenting the state's evidence, particularly those who may be called as a witness. The identity of those involved, their motives, or any efforts to conceal their conduct go directly to the heart of witness credibility and the integrity of the state's case. The apparent leak is not only a violation of the court's non-dissemination order, it enabled Dateline to gild rampant speculation with a veneer of credibility when purportedly exclusive information surfaces through a media broadcast shortly before trial, particularly information attributed to unnamed sources with access to the investigation. It carries a heightened aura of credibility and secrecy that can deeply influence public perception. Unlike official disclosures, which are typically accompanied by context and procedural safeguards, leaked framed as exclusives are perceived as uncensored truths and the public was not meant to see. This insider framing enhances the material's persuasive power, suggesting it is both authentic and revealing of the state's hidden realities. The episode includes things such as repeated speculative assertions regarding the assailant's motives, including unfounded allegations of sexual motivation. Who said that? Dr. Gary? Did our buddy Dr. Gary say that? Didn't he talk about sex? Let's talk about sex, baby. Let's talk about Dr. Gary and crimes. Sorry, I'm really thirsty today. It's so hot out. So, repeated speculative assertions regarding the assailant's motives, including unfounded allegations of sexual motivation, dramatic reenactments and animations depicting the alleged crime, created by the show's producers without basis in the evidentiary record, emotional interviews with individuals connected to the alleged victims, accompanied by evocative music, photos, and videos designed to elicit strong emotional responses. Well, a quadruple murder, already, generates an emotional response, I would think. The broadcast repeatedly bolstered its speculative claims through the use of so-called expert commentary. So-called experts. That would be who was on the show. Dr. Gary. Oh, he's not going to be happy with this filing. I just know it. Including individuals identified as law enforcement professionals and academics. These commentators were permitted to take sweeping assertions about the defendant's alleged motives, psychological state, and personal history, none of which are grounded in evidence before the court, while the program repeatedly emphasized their training and research and years of experience to lend undue credibility to their conjecture. This type of testimonial mimicry improperly mirrors expert witness testimony in a trial setting without the safeguard of cross-exam or evidentiary standards, effectively presenting the public with a one-sided, unvetted narrative that shapes juror perception before any admissible evidence has been presented. While the program occasionally inserts disclaimers such as, "We don't know what happened," these brief caveats do little to mitigate the cumulative impact of an extended narrative constructed through selective imagery, emotionally charged reenactments, and detailed speculative descriptions of the crime. When viewers are presented with a cohesive, visually enforced sequence of events, especially when paired with commentary from individuals styled as experts, the overall presentation fosters a sense of authenticity and truthfulness that is difficult for viewers to disregard. An occasional passing verbal disclaimer functions more as a legal formality than a meaningful check on prejudicial perception. And most viewers will leave the impression that they have seen a reliable reconstruction of events. The Dateline special, which aired just weeks before the trial date, will not even be the last pretrial media bombshell. Best-selling crime author James Patterson has written a book about the murders entitled The Idaho 4, An American Tragedy, scheduled for release on July 14th. Just 16 days before jury selection is slated to begin. Amazon. On Amazon. The blurb for the book describes Mr. Kohberger as, quote, a brilliant grad student, loner, a parent incel, and explicitly tells the reader, quote, now you are the jury, the evidence is in. The publisher boasts of unmatched access to the investigation, including interviews with local law enforcement. This suggests that the apparent Dateline leak was not the only violation of this court's non-dissemination order. The 6th and 14th Amendments guarantee the right to a fair trial by an impartial jury. A continuance is necessary to fully investigate the leaks and to mitigate the prejudicial effects of such inflammatory pretrial publicity occurring so close to the trial date. In sum, the 2-hour Dateline episode is uniquely prejudicial in both tone and content. It constructs a speculative narrative around motive and guilt, features emotionally manipulative production elements, and amplifies unsupported theories through self-styled expert commentary. All timed to air just weeks before trial, when jury impressions are most vulnerable and voir dire least equipped to neutralize such deep-seated bias. The forthcoming book by James Patterson, which will arrive in the hands of potential jurors just 2 weeks before voir dire begins, promises to set off a new round of inflammatory negative coverage and to deepen the pervasive bias against Mr. Kohberger on the eve of trial. The court has already acknowledged that the Dateline special exposes a likely violation of the non-dissemination order. Mr. Patterson's purported unmatched access to sources, including local law enforcement, suggests that multiple unauthorized disclosures have occurred. Depending on the results of the investigation into leaks, a continuance may be adequate. Once the sources of the leaks are identified and the full extent of misconduct revealed, the violations could warrant remedies more serious than delay. Come on. Come on. More serious than a delay. Shane, thank you for your super chat. Mwah. I love you. Thank you so much. I mean, come on. Not everybody's going to buy this book either. And not everybody watches Dateline. She acts like everybody in the world is getting a copy of this book when it comes out. Like, we're all just going to, like, get a copy of it automatically. Reversal is more likely than not in any case resulting in a death sentence. Statistically, almost 2/3 of death penalty cases are eventually overturned due to errors, often many years and decades after the initial conviction. Then she gives a list of all these. Mr. Kohberger deserves a fair trial from the outset to prevent an arbitrary or wrongful conviction and potential death sentence. These cases underscore the critical importance of thorough investigation. This diligence is essential to avoid the costly and time-consuming process of reversing a conviction and death sentence years later or decades later. And then a continuance is reasonable and necessary under the circumstances. Listen to this. This request is not made lightly. Defense counsel has worked around the clock, actively preparing for trial since appointment to this case. Filed all motions in a timely manner, complied with expert disclosure deadlines, and had expected to proceed on schedule. However, it has become clear that without additional time, the defense cannot complete review of the necessary discovery, meaningfully respond to all of the state's amended expert disclosures, and incorporate the information into an effective defense, and finish critical sentencing phase investigations. While prompt administration of justice is important to both the state and Mr. Kohberger, the constitutional guarantee of a fair trial outweighs modest delay. Modest delay? It's already been 3 years. Noelle, welcome. Thank you for joining today. It's good to have you over here. And because the majority of cases ending in the death penalty are later overturned for error, the public interest lies in ensuring a fair trial in the first instance. A continuance will ensure that Mr. Kohberger's fundamental constitutional rights are honored and that any verdict rendered rests on a fair and complete presentation of the facts, not on forced haste. Dated this 20th day of May 2025, Ann C. Taylor. So I'm thinking this is going to be denied. I'm thinking it'll be denied. What do you guys think? Do you guys think this will be denied? It seems like a bunch of hogwash, if you ask me. I think that they've had plenty of time. But you know what the judge said is that he may have to sequester the jury. Like OJ. And then we have this. Let's see. Let's just click through these. Bryan Kohberger. He is moving the court for an order to seal the notice of filing defendant's objections to the jury questionnaire. You guys think denied? I think it'll be denied too. I mean, she's had a lot of time. It's not like things were just thrown upon her. You know what I mean? I think the judge will definitely sort them out. The show will go on time, I think. So he's objecting to the juror questionnaire. We have that. And then we have that it's sealed. And that was yesterday. So they're also objecting. And then they sealed Exhibit F. But they did have a hearing 2 days ago. I'm going to show you. Exhibit F. Order sealing Exhibit F to defendant's 6th supplemental response to discovery. But we have here. Where is it? Amended notice of compliance. Okay, so they had a sealed hearing on the 21st, which was 2 days ago, which would have been on Wednesday. So this sealed hearing on Wednesday says that it was on Zoom, and it was a discussion regarding the role of victims. So the role of the victims in this case. I'm kind of glad they got the new judge. He doesn't fuck around. No, he doesn't. He's no nonsense. It would be amazing if he gave her 1 week. Happy Memorial Day weekend to you too. It's me, Mike. So we've got that. Now I want to hear about the leaker. Do you guys want to hear more about what could happen to the leaker? We have Anjanette Levy. I really like her show. And she has her own YouTube channel now, Anjanette. I really like her. So she talked to this guy. I know he's pretty corny, but she asked him some really good questions. Let's go through a little bit of this. Let's start with what she picked out of the discovery and see if we missed it, or out of the filing and see if we missed anything. Here we go.
In the penalty phase, if the case reaches that point, the defense references the life history investigation.
See, we covered that. Do you think it's possible AT set this up? I think it's possible that Bryan Kohberger did this before he was ever arrested. I don't know why. I just have this weird feeling. Call me crazy, but I have this weird ass feeling that he did this and sent shit. I don't know why. Call me nuts. I'm wearing my tinfoil hat, guys.
Investigation would reveal any red flags that could be looked into, which would take time. Taylor says she's obligated to investigate beyond the mere surface level for mitigating factors to add context to Kohberger's life so the jurors could understand his choices, his behavior, and lifestyle in which he engaged. Taylor essentially says she has to be able to present a full picture of who Bryan Kohberger is to the jury by getting to the heart of who he is.
Hold on.
And that requires...
That volume is really low for you guys, isn't it? Hold on. Let me get some volume boost here. Here we go. I didn't realize it was so low.
To gather observations, records, and interviews to show, quote, how others perceive an individual and his place in the world adds an additional layer of...
Ann Taylor. Shane, Ann Taylor. Pretty hate machine. Thank you. If granted, imagine how much... Wait. If granted, imagine how that would encourage evidence leaks by desperate defense teams in future cases. I think it will be denied. That's a really good point. That's a really good point. Oh, Ramsland beans. Hey, Simpson Road, Larry.
Complexity to understanding the nature and magnitude of psychosocial stressors he encounters. Another reason this life history investigation is required is so counsel can identify all of the experts they need. Taylor says experts are essential in telling a client's story in a way that will answer all of the important why questions for the jury.
Is that kind of like what the psychologist did in Letitia Stout, remember?
Taylor also raises a point that going through discovery is much quicker for the state because of all of the resources prosecutors and police have. Taylor,
hey, I got a question for you guys. Okay, let's say there's a movie made on this. Who plays Ann Taylor? Who plays Ann Taylor? You know who I say? Courtney Love. Courtney Love plays Ann Taylor. Because Ann Taylor looks like a rock star who's been rode hard and hung up wet. Fight me. She does.
Taylor writes, thus, defense counsel's review of the discovery is not merely checking a box. It goes to the very heart of the ability to prepare and present a defense. Reviewing and integrating all of the evidence in order to tell the jury a coherent counter-narrative is essential to defending Mr. Kohberger's life. The state and its superior investigatory apparatus has spent years honing in on one specific story, that of Mr. Kohberger's guilt, and ignoring all other possibilities. Now let's get into the latest development, the evidence leaked to Dateline. Taylor says that Dateline aired information in its 2-hour special that was prejudicial and unreliable, and therefore likely inadmissible, meaning the jury would never see it. But viewers saw it if they watched. It included information about Kohberger's Google searches for pornography, about women being asleep or passed out, and Google searches about serial killer Ted Bundy, selfies from Kohberger's phone showing him wearing all black and a hood, and his viewing of stories about the Idaho murders, and searches for his own name.
Okay, so that's what Dateline leaked right there. Gwyneth? Oh, I think Courtney Love, man. With that black eyeliner she wears, she'd be looking like Alice Cooper met Courtney Love.
This information had not been made public before. It wasn't in court documents. And Dateline report. Taylor says a continuance is necessary because these leaked materials to Dateline were carefully curated to construct a narrative of guilt. And there's another reason she wants a continuance. Another book is coming out right before jury selection begins. Best-selling author James Patterson and journalist Vicky Ward are releasing a book entitled The Idaho 4, An American Tragedy, in July, 16 days before jury selection begins. The book's cover boasts unmatched access, with months of local reporting with more than 300 interviews with victims' families and local law enforcement.
See, I brought you all this. I had a comprehensive show for y'all today.
Local law enforcement is, of course, covered by the non-dissemination order. Judge Hippler has already said he suspects that order was likely violated by current or former members of the prosecution team and law enforcement. Yikes. Taylor went on to criticize the Dateline episode, saying it had a lot of dramatic effects, like reenactments and music, coupled with emotional interviews with people connected to the victims. The show is another reason she wants the trial delayed. Taylor writes, in sum, the 2-hour Dateline episode is uniquely prejudicial in both tone and content. It constructs a speculative narrative around motive and guilt, features emotionally manipulative production elements, and amplifies unsupported theories through self-styled expert commentary, all timed to air just weeks before trial, when juror
Has anyone seen what Dr. Gary has said about this? It is skipping. What's skipping?
impressions are most vulnerable and voir dire least equipped to neutralize such deep-seated bias. And remember, Judge Hippler wants an investigation into the leaks, and so does Ann Taylor. She writes, depending on the results of the investigation into the leaks, a continuance may be inadequate. Once the sources of the leaks are identified and the full extent of misconduct revealed, the violations could warrant remedies more serious than delay. At the very least, however, a continuance is essential to allow the extremely prejudicial impact to partially subside and to give the court and the defense time to fully investigate and address the scope of the violations.
All right. So to talk about the defense.
Okay. So we're going to hear from him. This is actually a really good segment with him. I'm not saying a delay is necessary because of the Dateline episode, but I wish they would have waited on that mofo. Yeah, I hear you, Von Krul. Von Krul. I heard Bryan played Careless Whisper by Wham before entering the house. Are you serious? Where'd you hear that? So many cases had body cam footage all released before trial. So much evidence going out beforehand. Yeah, I agree. The gag order was pretty strict. But nonetheless, it's still a gag order, right? And judges take that seriously. Are you scared of my comments? Guilters, what do you mean? Why would I be afraid of your comment? Why are you deleting their comment? I'm not afraid of his comments. I know who killed you. You don't block them. I'm not afraid of them. I don't even know what they're talking about. It's the first comment I've seen.
His request for a continuance. I want to bring in Philip Dubé. He is court-appointed counsel out in Los Angeles, has done that type of work for many, many years. Philip, I'm not shocked by this request at all, especially given the Dateline special, but it seems to me that Ann Taylor had been working on this motion for a while. She'd been cooking this thing up, this 40-page motion for a while, and then the Dateline bomb lands in their lap. And they kind of slide that in at the very end. What are your thoughts?
I got to tell you, I actually sympathize with Miss Taylor, and I've been there. I really have. Here you have a guy whose life is on the line, and she's basically telling the court, I'm not ready. And in all fairness to Mr. Kohberger, he has a right under the Sixth Amendment to effective assistance of counsel. And the case law has interpreted that right to include the right of counsel to be prepared. If counsel is not prepared, then it would be unfair for the state to proceed, because really then it's almost like a trial by ambush. And it's not Mr. Kohberger's fault that his counsel is not ready. But she is, under Idaho law, setting forth the requirement of good cause. Good cause to delay the trial means that she needs more time to prepare, to investigate, and certainly to look into that Dateline leak.
Hold on. Valerie, are you talking to me? Too bad Dr. Gary blocked me. He didn't block me, dude. What are you talking about? There's no sound? You guys, is something going on with the stream? Like, hold on. Am I getting trolled? Hold on.
That Dateline leak is significant constitutionally and statutorily for Bryan Kohberger because under Idaho law, if that leak is in any way, shape, or form ascribable to the prosecution or law enforcement, she might be able to get counts dismissed or the case dismissed based on outrageous government conduct. And she owes it to her client to look into it, to see if the state or law enforcement had a hand in that leak. And if they did, I'm telling you now, I could see a judge maybe kicking a count. Now, the practical reality of it is it's going to be a very unpopular ruling, and she would have to show outrageous government conduct. And on these facts, I'm not so sure that law enforcement or the DA's office had a hand in that leak. We saw something similar with the Richard Allen prosecution, the Delphi murders, where defense counsel had all the discovery, crime scene photos, autopsy photos in their conference room.
Sure.
And somebody misappropriated them and then leaked them. Well, it's not so outrageous or ascribable to the attorneys that happened, but instead you ascribe it to the person who actually did it. And a dismissal would be unfair under those circumstances.
Sure.
Well, that's a good point because we did have the crime scene and other evidence leaked in the Delphi case, and the show went on. The show went on.
Sure, of course. And obviously that leak in that Richard Allen case was, completely inappropriate and horrible. It showed crime scene photos of Abby and Libby. It was awful. But this is on a much larger scale. And, Philip, this was discovery material. Judge Hippler made it clear in his orders, ordering both sides to preserve all communications with people about this stuff. He made it clear he thinks it did come from the state side, whether it was a current or former prosecutor or a current or retired member of law enforcement. He's made it clear. He thinks it came from the state side. So the law enforcement side of things, and he's made it clear too, he wants an investigation. So if it did come from law enforcement and there is a clip out there floating around of Keith Morrison saying they've developed a long list of people on the inside who are good sources. I mean, who would have access to that? This is discovery material. This is stuff off of Bryan Kohberger's phone, that Google searches, his photos, all this stuff that your average Joe wouldn't have access to.
All the intermediaries of the attorney-client relationship would have most of the discovery. So that means, first of all, Ms. Taylor and her team, meaning her paralegals, her associates, her second chair, and whoever else she has. Additionally, anytime she appoints an expert, they get the file as well. Now, does that mean the expert leaked something? Who knows, but I sincerely doubt it, okay? But moreover, the prosecution has it. And they have a huge office of people. They have secretaries, they have paralegals, they have social workers, they have their own investigators. And then you have the outside agencies, namely the law enforcement agencies that are working with the prosecution. So there is no way to know unless you open up an investigation. But let's assume the judge appoints a special prosecutor. Based on my research, it's only a misdemeanor if somebody did that.
Wow.
Or a contempt of court. A contempt of court under Idaho law carries 5 days max in the county jail and a fine.
Oh, wow. What? Do you hear this? There's literally no repercussions to this. I'm thinking it was the defense, too. Ann DeLay Taylor. Welcome in if you guys are just joining. Hit that like button. It's a free way to support me. I appreciate you. But did you hear that? Let's play that part again. It's a misdemeanor. No one's going to get in trouble, right? I mean, as far as like criminally.
Joe wouldn't have access to.
All the intermediaries of the attorney-client relationship would have most of the discovery. So that means, first of all, Ms. Taylor and her team, meaning her paralegals, her associates, her second chair, and whoever else she has. Additionally, anytime she appoints an expert, they get the file as well. Now, does that mean the expert leaked something? Who knows, but I sincerely doubt it, okay? But moreover, the prosecution has it. And they have a huge office of people. They have secretaries, they have paralegals, they have social workers, they have their own investigators. And then you have the outside agencies, namely the law enforcement agencies that are working with the prosecution. So there is no way to know unless you open up an investigation. But let's assume the judge appoints a special prosecutor. Based on my research, it's only a misdemeanor if somebody did that, or a contempt of court. A contempt of court under Idaho law carries 5 days max in the county jail and a fine. If you find that it was a form of obstruction of justice, and in other words, obstructing a public officer in the performance of duties, and in this case, it would be the judge. The judge is the public officer. It's a misdemeanor. So you really want to open up a huge investigation, appoint a public prosecutor, a special prosecutor, so you can get somebody on a misdemeanor. At some point, you have to cut your losses and use the voir dire process to find out what, if any, effect this has on a jury pool out there at large. Because I think that this can be cured during the voir dire process. You merely find out from all the prospective jurors what, if anything, they've heard, what, if anything, they may have seen on television. Did they even see the Dateline episode?
Exactly.
If not, then in the end, it really could be much ado about nothing.
The Dateline.
See, exactly. That's why they just have to be more, they have to use the jury selection and be, they have to be more they have to scrutinize more. This isn't a fair fight until Judge Hippler lifts the gag order and we can see all the discovery. Well, that probably won't happen till trial, Duckman. That's what trials are for.
Part of this is just one piece of this puzzle. And, we'll move on to the other pieces of the puzzle here in a moment. But, it appears there is probably more than one potential leak. And so let's say somebody that wasn't a law enforcement officer handed this material that is discovery material to Dateline. What if it was a law enforcement officer who handed it over to a third party to work as an intermediary or a proxy, whatever? That's still a violation of the non-dissemination order, and it's still potentially a violation of Bryan Kohberger's rights.
Of course. Remember, all of these materials are under, euphemistically, we call it a gag order, but really it's a protective order. And it's designed to prevent him from being prejudiced pre-trial. The goal is to make sure he gets a fair trial where he gets an untainted, impartial jury. And if everybody got a taste or a whiff of the evidence and maybe formed final opinions about him, he's not going to get a fair trial. But it goes back to what I said earlier, why Ann Taylor wants more time to look into this is because if she can show that this was in fact an intentional leak on the part of law enforcement, her remedy is to bring a motion for a dismissal based on outrageous government conduct. And the court can suppress evidence, the court can kick counts, the court can dismiss the entire prosecution outright. So there's a lot at stake for her client. And truthfully, I think it would be legal malpractice for her not to look into it.
So he's saying she has to do this. She has to look into this, right? But did you already said that it could go as far as getting rid of the whole defense team? I don't think that'll happen. Do you? True crime and other stuff. Do you think that Ann Taylor thinks her client is innocent? I don't know. Do you? Duckman, you're kind of cracking me up. I'm not sure it's been tainted. Like Hippler said, if Cyre's sworn testimony is true, Ashley Jennings could be disbarred. When you read 1,000+ pages of court transcripts, there's a lot of shenanigans from the state. I just don't think that anything in that Dateline was really that crucial, to be honest with you. I mean, if it makes him look guilty, maybe it's because he is. Do you know what I mean? Have you ever thought of that? That maybe this shit looks really bad because it fucking is? You know?
She now has something to hang her hat on. And that would be fascinating to see how courageous Judge Hippler would be on these facts. Seriously doubt it. There's a body of case law already developed on this issue, not just in Idaho, but federally, where prosecutors and law enforcement have eavesdropped on attorney-client privileged communications and seized on their theory of the case, their defenses, their strategies, their tactics, and even under that set of facts, the courts haven't found that it rose to that level of outrageous conduct, and they denied the motion to dismiss. So even assuming that she brings her motion, it doesn't mean it'll get granted, but I still think she's duty-bound to investigate it and to bring it.
Well, and then if the case still proceeds to trial and say they do identify the leak and it is law enforcement and that person's on the stand, she can then grill that person about that as well.
It's fair game. Absolutely. And again, I think criminally, the only thing that could happen is a 5-day contempt in jail.
Yeah.
Or they could file that misdemeanor, which I doubt they would do. You cannot compel a prosecutor to file criminal charges against their own, especially if it's just a measly misdemeanor. There's not enough meat in it to even pursue it. But I can tell you, whoever did this, their career is over.
Oh boy, did you hear that? They may not get in legal trouble, but he said their shit's over, their career's over.
Against their own, especially if it's just a measly misdemeanor. There's not enough meat in it to even pursue it. But I can tell you, whoever did this, their career is over.
Right. Let's go now to the other issues. She says, I haven't had enough time. I'm not ready, like you mentioned earlier. I haven't had enough time to investigate all the theories of the case, alternate suspects, all that stuff. I need more time. Simply, I just need more time. And, you know, I need more time to look into mitigation stuff, you know, family history, all this stuff. And this is a capital case. And she's basically saying to the judge, you might be causing, by not giving me more time, you know, reversible error.
And she's absolutely correct. It is not uncommon in the criminal defense world where counsel has a capital case that has been pending for 4 or 5 years. It can take a long time to work up that mitigation. I cannot tell you, Anjanette, often we have to send investigators or we ourselves have to travel abroad to meet with ancestors, to meet with relatives of our client. They live in Europe, they live in Africa, they live in Central America. We have to bring interpreters with us to interview people, get statements, to find out what, if anything, went on during that client's life. What went on in their childhood? What went on in school? What went on in utero, for all we know? What was the client exposed to during gestation? All of that has to be vetted because a jury could hang their hat on for purposes of a mercy verdict. And if you don't look into it, it could be a form of ineffective assistance of counsel because the client has that right, not just in the guilt phase, but also in the penalty phase to have the effective assistance of his counsel. And to let it go and to not even try to get more time, I think it could win a reversal, maybe on the penalty phase, but not on the guilt phase.
So, Philip, if you're a betting man, does Judge Hippler grant this continuance?
I'm optimistic. She's going into court with really valid grounds.
He's optimistic.
She's not saying, look, I have a prepaid planned vacation. You know, I'm going to a destination wedding, you know, in Cabo San Lucas, anything like that. She needs the time to work up her client's case. And to turn her down when she has so feverishly asked for it and shown the good cause.
Y'all, if they do a continuance, all these people have like reservations. They've all spent like thousands of dollars to reserve their places. I'm talking about family members. But let's go back to what he said. Think about Delphi. Think about the crime scene photo leaks. Think about all of the Odinism. All that stuff that was leaked out, right? Imagine if the crime scene photos of the Idaho 4 were leaked. Hey, Pines. Imagine if the crime scene photos of the Idaho 4 were leaked. I mean, we have some things, like the audio was quite shocking. Seeing the car was shocking. But Dateline they don't have to do anything. She'd be looking rough, man.
I think his hands will be
Oh, Helen Hunt. That's a good one, Noelle. That's a really good one.
tied to turn her down. Now, what he might do is give her a short continuance and keep her on let's take a look at your progress maybe in a month or two, and then revisit the issue, but maybe not give her as much time as she wants for now. But I think for
Oh, man, if he gives her any time, it's going to screw all this stuff up.
now, he should give her, at a minimum, a brief continuance so she can show good faith efforts and in earnest that she needed that time.
What's brief? Like in court time, that could be, what is that, 60 days, 30 days? What's brief?
Personally, I think 90 days would be fair to keep her on a short leash.
90 days? That would take us into December. Can you imagine this shit not starting now until 2026?
I mean, the practical reality of it is 90 days is not a long time. And when you need to do investigations, interview people, get people out in the field to canvass, talk to people, get statements.
Vaughn, you have a really good point that Anjanette did not bring up to this lawyer. He said, I don't mind her trying everything because it's a death penalty case, but Hippler will need convincing for a delay, and he'll be asking why they didn't ask for more help. Because didn't he ask them not too long ago, do you need more help? And she said no. She was like, no. Duckman, you said, no way Hippler's going to trial. Idaho is ball shrinking cold in December. The judge timed it so the trial would be finished before the 3-year mark from that night. All right, we're almost done with him, guys. He's annoying you. Calm down, Oscar Mayer.
Turn it over to the prosecution. They are likewise going to need time to look at it so they can rebut it. Last thing you want to do is ambush the prosecution with all your investigation and leave them hamstrung during the mitigation phase of a trial. So it kind of works both ways, and it could be that the prosecution might need time. Now, oftentimes what we do too as defense lawyers, we stipulate to a reasonable continuance for the prosecution. So even though we need the time, we will not object if the prosecution needs more time. So it's sort of a give and take. And if you agree to that, the prosecution won't balk.
Philip Dubé, thanks so much for your time, as always.
I like that guy, Philip Dubé. Jay, is he trying to get the trial date to the killing date? He may be. That's what I picked up what you laid down, Duckman. I think Hippler will go to trial too. I do. I just think he's going to deny the continuance. But then I also have the thought, what about, this is a capital case. What about, appeals? Patricia Arquette, she'd be a good one. What about Rosanna Arquette? Wasn't she the one that played Madonna in Desperately Seeking Susan? I've heard whispers of a new trial date, January 2026. I mean, who knows? But look at Anne. She's going, mwah. She's doing her job, guys. I mean, I'm not a big fan, but she's doing her job, I think, for Kohberger. Right, Sylvia, that's the thing. Like, why didn't she ask for more help if that was the case, right? So as of right now, on July 30th is when they're supposed to start doing jury selection. Where did Bryan park his Elantra? Probably behind the house. What do you mean? Oh my God, Urban. Right. She was like playing Madonna like she was mistaken as Madonna. I still got Corey Feldman cast as Miss Taylor. Shane. That is so funny. I think Hippler wants to stay on schedule. I don't think this is going to give them the delay they want. I don't. Shell, thank you so much. She says, game over. Thank you for your super sticker. Well, we've got that book coming out. So are you guys going to read the book? How about I get it and we read it live? I wonder how many pages. Hold on. Let's look at the book. I need to know how many pages it is before I commit to anything. Let's see. 448 pages. Do you think we can do it? I want to read the damn book. I'm not going to be picked as a juror, so what do I care? So it's 448 pages, and it comes out in July. Audiobook. I'm curious. I mean, it sounds like they've talked to a lot of people, right? Oh, yeah, we can break it up into parts. If you read it, I'll listen. All right. I'll order it. We'll get it in July. We can do it in parts for sure. And I'll just kick back with my book. You will, Evelyn? The audiobook, though, reads it for you, though, right? The real Santa Claus is prosecutor. He does dress up like Santa. Can Ann Taylor buy a K-bar and bring it to the courthouse? What? They're going to have a display case, I guess. I'll get the book and read it to y'all. That is really nice, Evelyn. Thank you. I think Hippler, this ain't his first rodeo with a big trial, so I don't think he's going to play any games. I think he'll do the right thing, and I think it'll end up being all right. I hope. But I'm going to wrap this one up. This concludes this Friday Live of Friday, May 23rd. This is Memorial Day weekend, you guys. Enjoy your weekend. It's a long weekend. I hope you guys have some plans. We're officially welcoming in summer for all the people that complain how cold it is all the time. Your summer's on the way. Oh, all right. Bring hot dogs. All beef koshers. You can pre-order it now. I want to hear you read it. No AI. Yeah, I'd rather read it myself. Thank you, guys. Have a great weekend. And it was very, very nice seeing you guys. All of my moderators, thank you for being here. You guys are awesome. Ooh, someone just fired up their... This guy across the street from me just fired up. He got a new Mustang, and he thinks he's cool as shit. Can y'all hear it? I mean, it is a 5.0, but I know you can hear it. Can you hear that? Let me tell you, it's not so funny at 6 a.m. See you at the grub truck. Aw, Jammers, I hope you had a safe trip. It was good to see you today. Kels, I know. Replay crew. All right, guys. It was good seeing all of you today. Peace out. If you please hit the like button on your way out. Thank you, Regina. Thank you so much for your support today. Super stickers, super chats, memberships. You guys are all amazing. You're what's keeping the wheels turning over here on Jay is for Justice. Thank you. Thank you. Have a great weekend. Let's run our credits, and I'll see you in the next one, y'all. Thank you so much for watching. If you enjoyed this live stream or video, make sure to give it a thumbs up and hit that subscribe button so you don't miss out on my latest content. Want to take it a step further? Bring it all in. And join our community clickers by becoming a Patreon or a YouTube member. You'll get exclusive access to our Discord server, special channel perks, and much more. Until then, I'll see you in the next one.
Click, 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 click. It's real easy, man.
I don't give a damn, I don't really care about you and your problems. I don't give a damn, you talk way too much. I have heard enough about you and your problems. I don't give a damn, I don't give a damn, damn, damn. I don't give a damn, damn, damn. I don't give a damn, damn, damn. I don't give a damn. You wanna be with me. You wanna feel something real, but I'm feeling differently. You're making plans to get to friends, but don't wanna face the fact that I ain't got time, I ain't got time, I ain't got time for that. Staying up late, sleeping all day, dreaming about Cadillacs. Buying new shoes, hanging by the pool, sipping on Coke and Jack. Calling my phone when you feel alone, but I'll never call you back. 'Cause I ain't got time, I ain't got time, I ain't got time for that. I don't give a damn, I don't really care about you and your problems. I don't give a damn, you talk way too much. I have heard enough about you and your problems. I don't give a damn, I don't give a damn, damn, damn. 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 You're mad at me for not giving you comfort. You say that I'm away so much, and now you don't feel the way you felt when we were younger. But that's okay for me, 'cause I don't give a damn, I don't really care about you and your problems. I don't give a damn, you talk